Attention, Canadians. Do you feel disconnected from our current political system? This could be our last chance to take a real legal stand for our rights. It's time to shift the political power to its rightful owners, the Canadian citizens and Indigenous peoples of Canada. Dive into our history, understand the need for change, and embark on the quest for true democracy. Are you concerned about our nation's commitment to human rights and self-governance? The power shift to freedom aligns with vital treaties and international laws enabling us to claim our rightful place as collective head of state. We advocate legally replacing the Crown, King Charles III, and our partocracy system with a true democracy, the peoples as the true collective head of state with veto power over our governance, to ensure your voice counts more than party interests. When our national collective civil and political rights are respected, your influence on policies will be direct and impactful. Join us on this noble struggle to make every Canadian and Indigenous peoples a meaningful participant in our future as collective head of state, which was legally owed and kept from us since the patriation of our Constitution, an official decolonization from the United Kingdom of 1982. It's time to correct the past of our government's lies and omissions to the people of our great country before it is too late. People 15 years old and over can sign our Canadian People's Referendum at canadianreferendum.ca and unite for our rights as the collective head of state in our Constitution. Together, we can be the example in reshaping Canada's future, not just for us, but for all peoples worldwide, once and for all. Are you ready to be part of this transformative movement? Join the Power Shift to Freedom movement by the Canadian People's Union and be part of a bold vision for Canada's future. Visit thecpu.ca for more details. Embrace and face the change required on your part to shape our future. People as the collective head of state constitutional referendum 1982 to 2024. Binding living document. Legal notice of intent and demand. Letter to King Charles and Governor General to replace the Crown with the people as collective head of state. To all Canadians, the true shareholders of the Crown of Canada and Crown corporations, for the sake of our country, please read and e-sign the People's Referendum, which is also our letter of independence from the Imperial Crown. You must be a Canadian citizen, 15 years and older, to sign. When you sign, your name and personal information are not displayed anywhere. The people as the collective head of state. Constitutional Referendum 1982 to 2024 Binding Living Document. November 3, 2024. Referendum Objective. The Canadian government has had an obligation to hold a nationwide constitutional referendum for its citizens, predating the Canada Act 1982 request by the Parliament and Senate to the United Kingdom, which only partially patriated the Constitution on April 17, 1982. The UK Commonwealth Foreign Affairs stated that due to the government not having held a referendum prior to the constitutional patriation from the UK, the Imperial Parliament could not proceed as Trudeau had hoped with the patriation. Instead, Pierre Elliott Trudeau was obliged to accept post-patriation amendments that have yet to be fulfilled 42 years later, and kept it from the people to this day. Constitutional amendments can only be accepted by the Imperial Parliament in accordance with the wishes of the people of the Dominion as a whole, not at either federal or provincial bidding. Decolonization. Patriation of the 1982 constitutional coup d'état should have given complete independence and the full power to the people to choose what we decide together in regard to our own country. This was never finalized and served as a parliamentary and provincial inside coup d'état against the peoples of Canada. This coup d'état was further extended as of April 17, 1997, to Her Majesty Queen Elizabeth II and now to His Majesty King Charles III as Canada's heads of state. Therefore, the Canadian people hold the prerogative to rectify the purported 1982 coup d'état, which allegedly undermined the constitutional patriation of the Canada Act 1982. Orchestrated by Pierre Elliott Trudeau's Liberal government, Parliament, Senate, and the provincial premiers, the Canadian government enacted the legislation without securing a mandatory referendum from affected Canadians regarding keeping the monarchy or the Canada Act 1982. Because we were not given a referendum on these issues and on how we wanted to govern ourselves, the Canada Act 1982 was enforced without our consent, thus maintaining the Crown and Parliament's supremacy over the people. Foreseeing democracy, parliamentary democracy, as the only legitimate outcome cannot truly be considered a free act of self-determination. The Canadian government has repeatedly violated the international legal instruments it pledged to uphold, undermining the rights and dignity of all Canadians. Regrettably, previous governments have also committed numerous human rights abuses since 1982, with the situation worsening significantly in the past 4 years. In a statement made during the parliamentary meetings, Sir B. Brain stated that the Canada Bill sent to the UK by the Canadian government, that certain parts of the Charter breached the international agreements that both Canada and the UK had ratified. There is much more shocking information within the Hansards that indicates that a coup d'état was committed against us by our own government and by every other government for the past 42 years since. The evidence suggests a systematic undermining of democratic processes by governmental authorities over the past 4 decades. See discussions in UK Parliament regarding Canada Bill 1982, Canada Bill Hansard. UK House of Commons Debate 17 February 1982, Volume 18 CC 292-373. My honourable friend, the member for Essex South East, Sir B. Brain, has shown clearly and cogently how certain parts of that charter offend and infringe 2 international agreements to which we are signatories, Article 17 of the Universal Declaration of Human Rights and Articles 1 and 27 of the International Covenant on Civil and Political Rights. Some of us may not wish to be signatories to those 2 agreements, but we are bound by them. So long as we choose to be fettered by those covenants, they remain shackles upon the House, and we should recoil from any legislation that infringes upon them. To do otherwise would be dishonorable, even disreputable. It is of course true that Canada is also a signatory to both agreements, but whether she decides to infringe them is not a matter for us. 2 wrongs cannot make a right. The Indian nations are justified in questioning the bona fides of the Canadian Prime Minister. I say that with great regret. As long ago as 1969, he spoke in Vancouver about the need to bring to an end the historic treaty rights of the Indian peoples, and spoke of how in due course those rights must be extinguished. He refuses even now to sit at the conference table to discuss and define what those rights are. He will not do so until the new Constitution of Canada is established, and at that stage he will have the power to override the Indians. That is our dilemma. We do not wish to offend Canada, but if we pass the bill in its present form, we shall infringe 2 international agreements and at the same time disregard the rights of the Indian nations given under 83 treaties between them and the British sovereign. For that reason, I shall find it difficult to support the bill. People's referendum purpose. This referendum is a legally binding living agreement between the signatories to achieve the required 51% of Canadians being in agreement with this referendum within a minimum of 7 provinces to reach a fair majority of our citizens. This referendum is to be combined in conjunction with the Indigenous and Civil Unified Sovereign Enactment, Citizens' Convention of Consent to Collective Self-Determination and Self-Governance, within a combined direct democracy system of governance, dishonor of the dignity of the Crown, abuse of power and breach of trust, no confidence in the Crown, the Canadian government, Parliament, provincial legislatures, and Senate. The public has grown increasingly distrustful of the government, legislators, and the Senate due to alleged corruption, disregard for citizens' rights, and the mishandling of public funds and health care. The Governor General had the full rights to remove Justin Trudeau the minute allegations of corruption were made. A Prime Minister can be removed even if he has the support of the House, if his actions harm the dignity of the Crown, if the people or the Governor General have lost confidence, or if he has breached the constitutional order. The Australian Governor General dismissed the Prime Minister, who had full support of the House in 1975, by using the personal reserve power of the Crown, of which the Queen was aware of, but only after the fact, and was pleased with his judgment in preserving the Crown in Australia. Please see the Palace letters released in 2020 in Australia regarding the reserved personal powers of the Governor General and the Crown. Constitutional lawyers will have to revise all the private letters of the Queen and Governor Generals of the realms. Otherwise, everything they think to be correct regarding the reserve powers of the Crown will be proven to be wrong. Whereas, we the Canadian citizens find it necessary to move forward with this referendum to preserve the life of our nation in all aspects, given the current state of governance and the persistent misuse of authority, abuse of power, as well as the continued disregard for our fundamental rights, the will of the people as a whole. It is undeniable that any people entitled to the right to self-determination must exercise it freely, whether through a plebiscite, referendum, or some other agreed procedure. We as a people have the right to proceed with this referendum as long as the majority of the Canadian citizens agree to this referendum format and all it encompasses as our agreed-upon procedure of choice and free expression by signing this document. Representativeness of the government in the context of the right to self-determination is that the government and the system of government is not imposed on the population of a state, but that it is based on the consent or assented by the population, and in that sense is representative of the will of the people, regardless of the forms or methods by which the consent or assent is freely expressed. UK Colonization of Canada, 1867 to 2024. Governance in Canada has always been imposed on the people, such as we have seen in 1982 with the misleading partial decolonization, patriation of the British North America Act 1867 and Canada Act 1982. A people cannot give free expression when the truth is inundated through lies, cover-ups, and omission by the very governments they entrust. Because of these lies and omissions, Canadians and the Indigenous peoples are still a constitutional colony of the Imperial Crown and Parliament, whereas the United Kingdom Parliament still hold the only authority to amend our Constitution Act 1867 and the Canada Act 1982, Charter of Rights and Freedoms. Form of government. International law does not impose a restriction on the people's choice as to the form of government, as long as the exercise of that choice takes place in a free manner, without any external influence or coercion. Neither does it say that a government is supreme and has the final say over a people. Therefore, we the undersigned Canadian citizens freely agree to initiate our collective and personal civil and political rights, including all other rights we possess, to hold this referendum by we, the peoples of Canada, without the interference or hindrance by the Canadian federal, provincial, or municipal governments or the courts, through our recognized legal rights, binding on Canada and the United Kingdom to formally remove King Charles III as Canada's head of state, constituting a collective sovereign people as a whole, as the collective head of state within Canada, being the lawful collective and legal holders of its collective corporation, sole and corporation aggregates, and transferring to the people all powers of the Crown, including military and personal reserve powers, prerogatives, etc., elevating Canadians from a neo-colonial parliamentary democracy system to a combined parliamentary and direct democracy system of governance in Canada, within the required amount of time necessary to implement the changes, correcting our Constitution as need be, removing unconstitutional laws, neglecting our rights, and those made in errors and omissions, establish the rights of the people to veto legislation prior to royal assent by the Governor General, and Lieutenant Governors, number of veto votes required to be determined. Honoring Indigenous treaties, Rights and responsibility. Maintaining and safeguarding all Indigenous treaties, rights, governance responsibilities, and obligations held in perpetuity to them that were transferred to Canada from the Crown. Honoring Canadian and Indigenous peoples on each side of the two-row wampum and Silver Covenant chain treaties by creating seats for the Indigenous peoples in Parliament regarding Indigenous issues. We further undertake constitutional initiatives to placing the Governor-General as the Canadian people's representative under the complete authority of the people as head of state, require that the offices of the Governor-General, Attorney General, and Lieutenant Governors be chosen through the electoral process. We, the undersigned, agree that for the sake of preserving the life of our nation, our economy, our children, and our future, hereby formally notify the Governor-General that we do not support the numerous dishonorable and disreputable breaches of trust committed by Parliament and legislatures, the questionable financial abuse of the money votes for $2,002.75 billion of taxpayer funds voted in by Parliament for the year 2024-2025, policy mismanagement and illicit acts through the creation of unconstitutional bills that override the international binding agreements the Parliament has dishonored by criminally disregarding them since 1976, the funding of wars and genocide that is subjecting all Canadians at risk from internal and external retaliation without our consent. FYI, Crown responsibility and liability. The responsibility of the head of state is to maintain the honor and dignity of the Crown, and not allow the further demise of the Crown through the actions of our own politicians in government, who have become the real threat to the national security and stability of our nation. Adhering to the rule of law, international law, and human rights is essential, as maintaining a functioning government is crucial to avoid plunging the country into further turmoil. Statutes of Rome. Command responsibility and failure to act. Responsibility of civilian superiors. Canada removed all immunity for Canadian officials. By the Canadian government and the provinces implementing the Provincial Emergency Measures and then the unconstitutional, illegal Emergency Measures Act, without consideration to our non-derogation of rights, placed International Bill of Human Rights, protected Canadian convoy protesters in an armed conflict with the RCMP and police. These may qualify for internal crimes against humanity, and the Ministry of Defense Medical Countermeasures Consortium within our healthcare system connected to other countries could place all Canadian military, medical personnel, and parliamentarians, including the Governor-General and the head of state, King Charles III, in jeopardy of international law crimes against humanity and human rights abuses due to the consortium's action. The Canada, UK, Australia, and USA consortium's actions include the creation, along with Canada, dual-use potential, gain-of-function viruses since 2001. Note: a hierarchical superior in a non-military relationship with subordinates is criminally responsible for crimes within the jurisdiction of International Criminal Court committed by subordinates under his effective authority and control, where he knew or consciously disregarded information which clearly indicated that the subordinates were committing or about to commit such crimes. The crimes concerned activities that were within his effective responsibility and control, and he failed to take all necessary and reasonable measures within his power to prevent or repress their commission, or to submit the matter to the competent authorities for investigation and prosecution. Urgent demands to the Governor-General. The Governor-General, as the guardian of our Constitution, must swiftly uphold peace, order, and good governance, POGG, to safeguard our nation's security, finances, dignity, and prosperity through issuing by formal proclamation that our International Bill of Human Rights be immediately acknowledged and enforced by her title and office regarding her duties to the people and this country above governance, to remove the Liberal government. To immediately command that a caretaker government be put in place, to call for an immediate election, enforce the investigations of possible fraud, conflicts of interest, and subverting policy committed by Justin Trudeau, Chrystia Freeland, and other ministers within the Liberal cabinet and Parliament. The Governor-General should postpone the royal assent of all pending bills until a new Attorney General and Minister of Justice has been appointed, who will uphold our International Bill of Human Rights, the Syracuse Principles, and ensure the constitutionality of the legislation before its enactment, as our International Bill of Human Rights is inherent in the Charter of Rights and Freedoms. To ensure that the bills are void of words that do not conform to the rule of law, which allow a government to manipulate the meaning. Example: reasonable is found over 2,000 times in the statutes. These are words that are incapable of any fixed meaning because they denote a quality that is inherently subjective. Urgent demands to parliamentarians and senators to immediately refrain from allowing unconstitutional bills from moving forward, and to repeal all unconstitutional bills passed in the last 5 years and previously that infringe upon our International Bill of Human Rights and non-derogation rights binding on Canada and the UK, to review the infringement of these rights, which would also render most of the legislation that has passed through Parliament, the provincial legislatures, and municipal bylaws unconstitutional, to review and rectify all policies and actions undertaken within government agencies, unlawful mandates during the pandemic that infringed on our non-derogable rights, would also render many of the court judgments of the last 4 years in error of national and international law, to review penalties and fines needlessly charged to the public by all levels of governance and policing across the country, to pay attention by reading the UK Hansard statements made by members of the UK Parliament in 1982 in regard to the people's full rights, to become educated in the entire International Bill of Human Rights before allowing the passing of any bills through Parliament and Senate. This Canadian citizens' referendum is initiated through our legally protected rights ratified by Canada and the United Kingdom, 1948 to 1976. Canadian citizens exercising our collective civil and political rights to self-determination and self-governance within the International Bill of Human Rights, the Universal Declaration of Human Rights. Adopted and proclaimed by General Assembly Resolution 217A, 3 of 10th of December 1948, the International Covenant on Civil and Political Rights. Adopted and opened for signature, ratification, and accession by General Assembly Resolution 2200A, 21 of 16th of December 1966. Entry into force, 23rd of March 1976, in accordance with Article 49, ratified by Canada and the United Kingdom, 1976, the International Covenant on Economic, Social, and Cultural Rights. Adopted and opened for signature, ratification, and accession by General Assembly Resolution 2200A, 21 of 16th of December 1966. Entry into force, 3rd of January 1976, in accordance with Article 27, ratified by Canada and the United Kingdom, 1976, the Syracuse Principles, non-derogation of rights. We as a people have lost all confidence in our government, parliamentarians, and the provincial legislatures regarding the alleged corruption that has transpired in the malfeasant ignorance of our rights, the rule of law, and misuse of our funds. The Governor-General had the full rights to remove Justin Trudeau the minute allegations of corruption were made. Instead, we are witnessing the full demise of the honor and dignity of the Crown towards their fiduciary duty and responsibility to the people. Therefore, we the Canadian citizens find it necessary to move forward with this referendum to remove and replace King Charles III as our head of state, with the Canadian peoples as the collective head of state, corporation sole and corporation aggregate, represented by an elected Governor-General. Given the current state of Canadian governance and the persistent misuse of authority, abuse of power, as well as the continued disregard for our fundamental rights. ICCPR, the International Covenant on Civil and Political Rights, entry into force, Prosody, March 1976. In accordance with Article 49 Preamble, the states parties to the present covenant, considering that, in accordance with the principles proclaimed in the Charter of the United Nations, recognition of the inherent dignity and of the equal and inalienable rights of all members of the human family is the foundation of freedom, justice, and peace in the world, recognizing that these rights derive from the inherent dignity of the human person, recognizing that, in accordance with the Universal Declaration of Human Rights, the ideal of free human beings enjoying civil and political freedom and freedom from fear and want can only be achieved if conditions are created whereby everyone may enjoy his civil and political rights, as well as his economic, social, and cultural rights, considering the obligation of states under the Charter of the United Nations to promote universal respect for and observance of human rights and freedoms, realizing that the individual, having duties to other individuals and to the community to which he belongs, is under a responsibility to strive for the promotion and observance of the rights recognized in the present covenant, agree upon the following articles. Part 1. Article 1. 1. All peoples have the right of self-determination. By virtue of that right, they freely determine their political status and freely pursue their economic, social, and cultural development. 2. All peoples may, for their own ends, freely dispose of their natural wealth and resources without prejudice to any obligations arising out of international economic cooperation based upon the principle of mutual benefit and international law. In no case may a people be deprived of its own means of subsistence. 3. The states parties to the present covenant, including those having responsibility for the administration of non-self-governing and trust territories, shall promote the realization of the right of self-determination and shall respect that right in conformity with the provisions of the Charter of the United Nations. Part 2. Article 2. 1. Each state party to the present covenant undertakes to respect and to ensure to all individuals within its territory and subject to its jurisdiction the rights recognized in the present covenant, without distinction of any kind, such as race, color, sex, language, religion, political or other opinion, national or social origin, property, birth, or other status. 2. Where not already provided for by existing legislative or other measures, each state party to the present covenant undertakes to take the necessary steps in accordance with its constitutional processes and with the provisions of the present covenant to adopt such laws or other measures as may be necessary to give effect to the rights recognized in the present covenant. Each state party to the present covenant undertakes a. To ensure that any person whose rights or freedoms as herein recognized are violated shall have an effective remedy, notwithstanding that the violation has been committed by persons acting in an official capacity. b. To ensure that any person claiming such a remedy shall have his right thereto determined by competent judicial, administrative, or legislative authorities, or by any other competent authority provided for by the legal system of the state, and to develop the possibilities of judicial remedy. c. To ensure that the competent authorities shall enforce such remedies when granted. Article 3. The states parties to the present covenant undertake to ensure the equal right of men and women to the enjoyment of all civil and political rights set forth in the present covenant. Article 4. 1. In time of public emergency, which threatens the life of the nation and the existence of which is officially proclaimed, the states parties to the present covenant may take measures derogating from their obligations under the present covenant, to the extent strictly required by the exigencies of the situation, provided that such measures are not inconsistent with their other obligations under international law, and do not involve discrimination solely on the ground of race, color, sex, language, religion, or social origin. 2. No derogation from Articles 6, 7, 8, paragraphs 1 and 2, 11, 15, 16, and 18 may be made under this provision. 3. Any state party to the present covenant availing itself of the right of derogation shall immediately inform the other states parties to the present covenant, through the intermediary of the Secretary-General of the United Nations, of the provisions from which it has derogated and of the reasons by which it was actuated. A further communication shall be made through the same intermediary on the date on which it terminates such derogation. Article 5. 1. Nothing in the present covenant may be interpreted as implying for any state, group, or person any right to engage in any activity or perform any act aimed at the destruction of any of the rights and freedoms recognized herein, or at their limitation to a greater extent than is provided for in the present covenant. 2. There shall be no restriction upon or derogation from any of the fundamental human rights recognized or existing in any state party to the present covenant pursuant to law, conventions, regulations, or custom on the pretext that the present covenant does not recognize such rights or that it recognizes them to a lesser extent. See full document. In the court of public opinion, truth and common sense will prevail. To be forwarded to His Majesty King Charles the United Kingdom, Imperial Parliament, the Governor-General of Canada, Provincial Lieutenant Governors, the Parliament of Canada, Parliamentarians, the Senators, the Provincial Premiers, the United Nations Human Rights Commission, the Organization of American States, OAS, the International Court of Justice, the International Criminal Court, all United Nations International Bill of Human Rights, Vienna Convention, and the Statutes of Rome signatory countries. Nicole Lebrasseur, CEO, the Canadian People's Union. Disclaimer: the texts included therein do not constitute any legal advice. The CPU, Canadian People's Union, is a civil and political rights union of Canadian and Indigenous peoples, activating their collective and personal rights to personal self-determination and self-governance according to the national and international laws in force, and whose rights are duly protected. Please note that their representatives act as researchers only.